Hi, my name is Kelly Halstead. I'm with the Greater Fort Dodge Growth Alliance. And thank you for joining us for the 2020 employment law, which is a new and improved, or I don't know if I'd say improved, but new and crazy employment law as of today. I want to say thank you and for supporting this with SHRM. Kristen Stanley's here. You want to have a plug for SHRM and a few words?
Yeah, just a reminder for all of our members to be watching their emails for our November meeting details. That'll be on November 11th. The SHRM certification number for this presentation I do have. If you need that, please email me and I can get that certification number to you. And then also we are going to be doing a planning meeting early part of November for next year's programs. So if anybody has any topics that they would be interested in hearing more about or presenters that you feel might be good, please reach out also to one of the board members, myself or one of the other board members, to give those ideas to us so that we can be sure to try to get those included in November or in next year's program. That's all I have, Kelly.
Okay, thanks, Kristen. Hey, could you put your email in the chat box just in case somebody needs that so they can
Good idea.
You. So how we're going to do this, I would assume Stu does not need any introduction. The man, the legend of employment law in Webster County and the region. If you haven't seen this before, you're in for a treat. Stu has been doing this for the Growth Alliance for as long as I've been here, I think. And it's a highly attended, highly professional, informational webinar now in our format today. And I'm just gonna have Stu take it away, but I do want to remind everybody, if you do have a question, you're able to put that in the chat box and we will take those questions at the end of the presentation. So with further ado, Stu, you want to take it away?
I will do that. I don't know how much of a treat it'll really be, but we'll move our way through here, folks. Welcome to the weird world of employment law 2020. This is unique for me. I was telling Kristen and Kelly that many of you are much more comfortable probably than I am with the webinar format. It's weird to not be able to see your faces. I can't tell if you're bored or making irritated looks or anything like that. So I'm going to work my way through the material, but remember that you drive a lot of my conversation through questions. You can redirect me anytime. Having done this a number of times, I'm often fooled by what questions are posed during the middle of these conversations. Sometimes you're wanting to address different issues. Don't be shy about doing that. Kelly's prepared to read questions as they come in, and when they do, we will shift gears and try to cover things that are of interest to you, because that's really what I want to do is discuss and highlight topics that are of interest to people that are listening. You're the people on the front lines. You know what the real issues are. I gauge my topics by what I'm asked as a lawyer, and sometimes that's a pretty good barometer for what you're all feeling, but not always. By way of introduction, again, employment law is an area that I've done for 35 years now, so I don't do everything for just employers. I consciously represent employees from time to time, and I say consciously because it keeps me on the cutting edge. Having represented employees, I get a different perspective once in a while. Primarily, I represent employers, and I like to see employers do things the right way. But I stay up to speed by playing both sides of the fence, if you will. So I think that gives me a unique perspective that not everybody always has. I do litigation and consulting, and this is one of the things that I like to do with employer groups. I go into organizations and do training and just kind of handle a hodgepodge of issues as they come up. So I'm going to cover a broad range of topics today. I'm just going to get into this and work my way through the presentation. You see it on your screen. And as you see, I'm going to start with COVID only because COVID is new. And I'm going to try to cover as much as I can in COVID. And then I will get into other topics like wage and hour, Civil Rights Act, things like that. If you want to get there before I'm planning to get there through my slideshow, don't hesitate to ask questions as we go. COVID. Now understand that like many of you or most of you, I've read the literature a whole bunch of times. That doesn't necessarily make me any more of an expert on COVID than you think I should be. The problem is lawyers rely primarily on case law. What we learn over the course of years is how courts define laws and how they interpret laws. Right now, we don't have the ability to do that because there's no case law out there. When case law comes down, lawyers will have a much better handle on how this is really going to be interpreted. Right now, I'm reading statutes, and you can't see my desk, but I got material floating all over here. So as questions come in, or when I need to, I'm going to refer to the literature and try to present the best information I can. So let's jump into COVID here and see where that takes us. The new federal employment laws. Most of you know that the Family First Coronavirus Response Act became effective April 1st. And I've just listed there on the screen those things that the Family First Coronavirus Response Act addressed. The ones that we really care about are primarily the Emergency Paid Sick Leave Act and the extension of the FMLA. The act went into effect on April 1st. They are not retroactive. So if you had employees on leave or needing leave prior to April 1st or on furlough prior to April 1st, they're obviously not covered by any provisions of the act. They weren't made retroactive. It only impacted people as of April 1st of 2020. Currently, the act is set to sunset on December 31, 2020, but hold your breath because this pandemic has lasted longer than I think many people hoped. I think there's a great chance that it extends. I think regardless of who takes the White House here in November, I see this act continuing into the spring, hopefully not longer than that, but at this point we really don't know. So currently everything is scheduled to sunset on December 31 of 2020. We just don't know if that's really going to happen or not. Okay, one of the things that I reference as part of the Family First is the Emergency Family and Medical Leave Expansion Act. It applies to public employees, private employees, and nonprofit employees employed by employers with less than 500 employees. So yes, there are some really big organizations that are excluded from coverage. 500 employees is nationwide. So if your organization employs 500 or more people nationwide, you are excluded from the Family First Coronavirus Response Act. It creates a new category for FMLA eligibility. So it truly is an expansion act. It's not a whole new act. It just added one additional component to the existing FMLA. Your employee must have been employed for at least 30 days before seeking leave under the expanded act. The expansion does not provide an eligible employee with an additional 12 weeks of leave. What does that mean? That means if Stu already took his 12 weeks of available leave under the traditional FMLA, if you're an organization that's covered by the traditional FMLA, then Stu does not get any additional benefit from the expansion. I don't get another 12 weeks of leave if I've already exhausted my 12 weeks of leave. The expanded leave is for an employee who is unable to work or telework due to a need for leave to care for the son or daughter under 18 years of age, if the school or place of care has been closed or the child care provider of such son or daughter is unavailable due to a public health emergency. That is the only reason for the expansion. There's nothing else. The expanded FMLA only provided that one additional opportunity for leave for employees. The first 10 days of the allotted 12 weeks of leave may be unpaid, except the employee may elect to substitute any accrued vacation leave, personal leave, or medical or sick leave. And again, folks, I can't see your face, so I don't know if what I'm saying is making sense to some of you or not many of you. So if you do have questions, slow me down. Just ask a question, ask me to repeat or explain, and I will be happy to do so. Under the expansion, those eligible employees are going to be paid 2/3 of their regular rate of pay. The maximum pay is $200 per day and $10,000 in total during the expanded 12 weeks. For those employees that are working varying schedules, the employer may look at the average hours worked over the past 6 months. And you're going to see this happen quite a bit because a lot of you employ people on different hours, different types of schedules. You're going to want to look at what they average and try to determine what that rate of pay will be. One thing we've not seen out there is a lot of litigation over any of these issues. And that doesn't mean that they aren't coming, but so far, I'm not seeing claims that are being made on how employers are interpreting the act or how employers are paying people under the act. That's a good thing. I think the Department of Labor also, if they come in and do an audit, an investigation of some sort of complaint, there's going to be a fair degree of leniency. They've indicated through their regulations that if employers are trying to abide by the law, if they're trying to do the right thing and they make a good faith error in either their calculation or the granting of leave, I do think employers are going to be cut some slack just because it's so new, because there isn't case law, there's not agency interpretation out there either. So for the most part, employers, if you're trying to do this the right way, you're going to be okay. But that does require that you make a good faith effort, just like this, in trying to average the hours to avoid responsibility and liability under the act. If the employee did not work in the past 6 months, you should try to estimate the number of hours the employee was expected to work. I don't know if this would really come into play much. You got to believe if the employee didn't work in the last 6 months, they're probably not on your active roster of employees. But that could happen. You could have somebody that's on layover, layoff, or doing something different for 6 months. Then you're supposed to estimate what they would work if they were employed over the next 12 weeks. Employees entitled to be restored to their job upon return from leave. It's just like the traditional FMLA. Once the employee is able to return to work, there is the expectation that the employee will be restored to their same or an equivalent job that provides the same essential pay, duties, responsibilities. Employers are not permitted to use the expanded FMLA to try to let people go. Once they're able to return from leave, you have an obligation to try to return them to that same or similar position. There's a couple exceptions. If you employ fewer than 25 employees, and by the way, anybody, I covered this, but remember, when I talked about FMLA in the past, many of you were able to just take a brief nap because the FMLA didn't apply to you because you didn't employ 50 or more people. This expanded FMLA covers you. It recovers everybody now with less than 500 employees. So that is, I think that's the big novelty for so many employers is many of you were able to just ignore the responsibilities of the FMLA because you didn't employ that threshold of 50 people. Under the new law, you're covered. And for many of you, that means you need to get up to speed on the reporting requirements of the FMLA. What forms do you have to complete? For those that always did the FMLA, that's not new terrain. But for those of you that have never done it, that means you're filling out those forms. You're providing notification of eligibility. You're doing the sorts of things that you've never had to do before. So for many employers, if you've never been obligated under the FMLA, you're going to want to familiarize yourself with those responsibilities of making sure that an employee comes to you, they explain their reason for leave, and you're responding to them regarding their eligibility. Yes, you're eligible, or no, we find that you aren't eligible. And we'll talk about a couple more things related to that. But I think that could be a big challenge for many employers that have never dealt with the FMLA before, because the FMLA is a law all by itself. It's unique. It has different reporting requirements. It's got different eligibility requirements. And while courts in the past have said that employers will not be liable if they grant the substance of the law, even if they haven't met all the reporting requirements, you still want to try to respond in writing to your employees and make sure your employees are told yes or no, you are eligible or not eligible for FMLA expansion. Okay, so that is different. And I don't know how many, I haven't gotten a lot of questions like that from employers, but I suspect there's a lot of employers that maybe haven't followed those reporting requirements just because they are new. Again, for those employers, if this is the first time you've had to orchestrate your way through the FMLA, I would just tell you to familiarize yourself with the substance of the law and make sure that if you've got employees that are eligible for the expanded FMLA, you're granting that leave. If you're granting that leave, yes, I want you to try to comply with the reporting requirements, but I don't want you to get hung up on whether you've met every deadline required. Did I get the notice to them on time? What if we didn't put it in writing? Now here we are almost in November, and I've never put anything writing to my employee that they're eligible for the expanded FMLA. Don't sweat that. As long as you've done what you're required in substance, you will not be responsible or liable for anything if you miss some reporting deadline.
Stu, Stu, we had a question regarding that. Is the 25 employees per location or a company as a whole?
Company as a whole.
Okay, thank you.
Okay, so you're obviously, whoever asked that question is looking at this slide, and I think this is one that really helps employers. Employers with fewer than 25 employees may elect not to restore the employee to their prior position if the position held by the employee no longer exists due to economic conditions or other operating changes caused by the pandemic, and the employer makes a reasonable effort to restore the employee for a period of 1 year. So remember though, that doesn't necessarily mean you can just not choose to restore the employee. It applies only if restoring the employee would be to a position that no longer exists. So that's supposed to be relief to employers who've had an economic downturn, and they just don't have the positions they used to have before. As a result of that, they don't have any choice. I'd love to restore you to your job, but frankly, we've lost half of our labor pool here, and we just don't have the ability to create a new job for you. Under those circumstances, you do not have to restore that employee. Now, here's an interesting question. So let's say you're greater than 25. Let's say you've got 60 employees. Now, does that mean you have to restore that employee? Maybe even though you employ 60 people, still due to the economic downturn, your labor force has changed dramatically. You no longer have the positions you had prior to last April 1st. Are you now automatically required to bring that employee back? I would still say no. And why? Because under the traditional FMLA, remember, an employee traditionally under the FMLA, you did not have to restore them to their job if their position would have gone away anyway. Because under the traditional FMLA, an employee on leave had no greater right to be restored to their job than if they had never taken leave to begin with. A good example would be an employer shuts down their entire maintenance department, and the employee that was on leave under the traditional FMLA was a maintenance employee. Well, it doesn't make sense then if my whole maintenance department has since gone away while the employee was on leave. why would I be required to restore that employee to their prior job in maintenance? Well, under the traditional FMLA, you were not. So my theory would be, and I don't have any case law to test this against, but my theory would be that if the position has just gone away, legitimately gone away, it's not by design, I didn't just do it to try to make sure I didn't have to restore the employee, the position just literally went away, I don't see any obligation for that employer to restore that employee to that position once they come back from leave. To me, whether you've got 25 employees or 50 employees or 100 employees, you shouldn't have to restore an employee to that position if that position legitimately went away. Now, that's not exactly what my slide says there, but because that's what the traditional FMLA says, I think that would still need to apply. All right, let's move off that. Healthcare providers and first responders are exempt from coverage. Now, this has taken a roller coaster ride since April 1st, and we all know that originally healthcare providers was defined as anybody who worked for anybody that was in the healthcare industry. And I primarily, to me, it impacts hospitals, healthcare facilities, long-term facilities. Originally, we were all operating under the impression or the assumption, because that's what the Department of Labor said, that any employee was exempted. That would mean secretarial, clerical, administrative, HR type people, anybody, regardless of whether or not they were involved in direct care with patients or residents or not. And that was what we all, the interpretation we all followed till September 11th. Okay, now definition of healthcare provider has been significantly modified. Healthcare provider now includes two groups of people. The first group is anyone who was a licensed doctor of medicine, nurse practitioner, or other healthcare provider permitted to issue a certification for purposes of the FMLA. And what are they talking about there? They're talking about if you've had an employee, if you were covered by the FMLA before, and you had an employee who had a serious health condition, we all know there were certain healthcare professionals who could sign that healthcare certification form to support the fact that the employee needed to be off work for a serious health condition. And that form, as we know, would indicate whether they needed intermittent leave, how long they needed to be off work, when did the leave need to begin, when did they expect they'd be able to return from leave. Okay, so that's the first group of people that are considered healthcare providers now. The second group is any other person who is employed to provide diagnostic services, preventative services, treatment services, or other services that are integrated with and necessary to the provision of patient care, and if not provided, would adversely impact care. We're talking about nurses, nurse assistant, medical technicians, essentially those people that provide direct care to patients. I think it also would apply to therapists. What it won't apply to is, you see some examples there: IT staff, building maintenance staff, HR staff, cooks, food service, records manager, consultants, and administrators. So what they did, and it makes sense, they basically limited the definition of healthcare provider to those individuals who are actually providing direct care to patients or residents, and not all of the other people that are involved in organizations who are not directly providing that care. So that's the change. So anybody who's got healthcare people that they employ, you still have the right to exempt those people if you choose to. And that gets into another topic that I think is really interesting. My conversation with a lot of employers, I know many of you have struggled with, do you exempt those people or not? And you get into a fairness consideration. Is it fair for us to exempt some of our employees and not all of our employees? So you have the right as an organization, and I think this is important to remember, you don't have to exempt anybody. You have the right to provide that care if you want to, and provide that leave if you want to. The Family First Coronavirus Response Act and the Department of Labor have been really clear that they encourage employers in areas of doubt, to err on the side of coverage. So as organizations, you still have the right to determine how you want to exempt or exclude some people from coverage. If you choose not to exempt or exclude those people from coverage, you have that option. You can grant that leave to everybody if you choose to. Okay, let's go to the next slide. Emergency responder is an employee who's necessary to provide transport, care, health care, comfort, and nutrition of such patients. It does include military or National Guard, law enforcement, correctional, firefighters, emergency medical service personnel, physicians, nurses, public health personnel. So again, emergency responder is another category of people that may be exempted from coverage under the Family First Coronavirus Response Act. The exemption for small business is an important one, and I don't know for sure how often this is getting used. I know it's getting used in some cases because I have drafted for some employers some of the required statements that an employer needs to put in place if they want to exempt under this exception. An employer with fewer than 50 employees is exempt from providing expanded FMLA leave and paid sick leave under the emergency paid sick leave if doing so would jeopardize the viability of the small business as a going concern. And next slide stays with that topic. The small business may claim the exemption if an officer of the business has determined that the provision of paid sick leave would result in the business expenses and financial obligations exceeding available business revenues and cause a small business to cease operating at a minimal capacity. The absence of the employee or employees requesting leave would involve a substantial risk to the financial health of the small business, or there is not sufficient workers able and qualified to perform the labor or services required. So, let's see my next slide. And now let's go back to that. So what does this mean? What it means is if you're a business with 50 or fewer employees, you have the right as an organization to determine that if you grant this leave that's available under either the expanded FMLA or the emergency paid sick leave, it is going to have such a negative impact on your business that you don't believe your business will remain viable. And why would that be? Well, some organizations, and I look at restaurant industry, I think they got hit particularly hard, and not alone, but I know they did for one. And the fear was that if they granted this leave, they're not going to have people show up for work. They're not going to have sufficient people to manage the operation. And if that is in fact the truth, and if in fact an officer of the organization believes that they won't be viable, the officer and the organization actually have the right to take the position that they're exempting themselves for coverage. Now, I think they've got to be careful. I've talked to a number of employers who have said, well, that's convenient, but I don't know if I can really say we're not going to be viable. If you don't think that you can meet that definition or that showing that we're not going to remain viable, be careful about just automatically exempting your organization from coverage. But in those circumstances where you do have a good faith belief that if we do this, we're not going to be viable, that's what this is for. This is to allow you an opportunity to exempt yourself from coverage. In those circumstances, if you want to exempt yourself from coverage, I recommend that your leadership in the organization actually, either if you're a corporate organization, that you actually pass a resolution, or if you're not a corporation, if you're just a standalone business, that you actually issue some statement that we have determined that it would impact our viability. We wouldn't be able to remain open if we grant this leave, so we're therefore taking the position that we're exempt. I think you can do that by corporate resolution, or you can just do that by issuing a statement if you're if you're a partnership or you're a standalone organization. But I think that's what you want to do. You want to make some documented effort to establish the fact that you've made this determination. So your employees know that, and if it's ever called in question, you can present that statement and say, hey, look, here's what we've determined we needed to do. Emergency Family and Medical Leave Expansion Act. Employees may not take 80 hours of paid sick leave under the Emergency Paid Sick Leave Act and then receive additional money from the FMLA Expansion Act. All that's really saying is you're not going to pay them twice. If they are eligible under the Emergency Paid Sick Leave for that 80 hours that we're going to talk about in a minute, then they're not entitled to duplicate that pay. I think that's kind of common sense.
Hey, Stu, I missed this question earlier regarding FMLA. So if we have more than 25 employees at this time, do we have to notify them of the expanded FMLA?
Yes. Remember, the expanded FMLA, even if you have 2 or 3 employees, you're covered under the expanded FMLA. That is the trick for many employers. Many employers are going to get caught up with the FMLA. They never thought they'd get caught up with the FMLA because they don't employ that 50 people. Now you're all covered, okay? So the answer is yes. There's notifications, there's postings from the Department of Labor, and you're going to want to get online. You're going to find out what posting you're required to post, but you are required to post. So the answer to that is yes, and that 25 doesn't come into play under the expansion of the FMLA. You're covered if you've got 19 or 20 or 2 or 3 people. You're covered under the expanded FMLA. So the answer is yes, you do need to notify your employees, and you do that through posting. Just like you post your other stuff in some conspicuous location, the lunchroom, or wherever you put those postings, you're going to want an expanded FMLA posting that you can get from the Department of Labor, and you can get that by just accessing that online. Think that answered that, Kelly?
Yeah, I think so. Yeah, thank you.
Okay. Expanded FMLA does not apply to employees who've already been laid off. I think I covered that with my opening statement. But remember, if you've had people on layoff already prior to April 1, you're not going to get concerned about the Family First Coronavirus Response Act. Those employees are just not covered. You may be concerned about them for other reasons, but you're not going to be concerned about them as it relates to this new law. The recouping of costs. Employers are entitled to recoup 100% of their costs through refundable payroll tax credits. So when this first came out last April, we were a little bit confused as to how that would work. Many of you have probably done that already through your quarterly payroll tax. I've not done that, so I don't know exactly how the mechanics are, but you are entitled to recoup 100% of your cost of compliance with either the emergency FMLA or the emergency paid sick leave. So if you are paying money out to your employees, you want to make sure that you are documenting that. We're going to talk about documentation here in just a minute, but you're going to want to make sure you are documenting that carefully because you're going to recoup 100% of that cost. Okay, the employer should retain appropriate documentation. What does that documentation look like? Well, as it relates to the expanded FMLA, since we're only talking about the need to be home to care for a child whose school or daycare is closed, that documentation would look like, number one, something in the newspaper or something online that says the school is closed. That's sufficient documentation. If it's a child care issue, then you're going to need something from either a child care provider. It could be an email from the provider. It could be a letter that the provider sent out to every affected family that says, hey, my daycare is closed. I'm sorry, I can't provide daycare to your child. That would be sufficient documentation. But there needs to be something in writing that documents the fact that the school or daycare has closed, because you're going to need that documentation to get your tax credit. The IRS forms will be provided in instructions. And my understanding is they're Form 941 or Form 7200. You're going to want to look at those forms. I suspect anybody that's doing your tax preparation would be familiar with those forms, but those are the forms that are being used to make sure you get reimbursed for that cost of providing this leave that's under the Family First. Employees must provide the documentation to receive the leave. I have not completed that, but I'm sure there's a place on that form that says you attach the documentation for each person that you're requesting to be reimbursed for. Employer should retain the appropriate documentation. Documentation may include things like notice. I think these are things I've already covered, just talking about the documentation that you're going to want to get. I don't know why I've already got a comment regarding telework in there, but we'll talk about telework here. Employee and the employer may agree to telework for part or all the leave. If you're doing telework because you and your employee have agreed that telework will work, then you can do that intermittently if you choose to. You could have an arrangement with your employee that they're going to work from home 4 hours a day. The other 4 hours, they're just not going to be able to work for one reason or another. If both you and your employee agree to the telework arrangement, then you may have shortened leave available to that employee, maybe 4 hours instead of the full 8-hour day. But that has to be something that you agree to. The employer has the right to say telework will work for this position, but not that position. We just don't think that this particular job is set up well for telework. You've got to be here to make it work. Other positions we all know, and I think the labor force is going to change, I think, forever. I think we've learned that teleworking does work in a lot of cases, in a lot of cases it doesn't work. But employers have had to learn that on the fly. But for those situations where you think as an employer that telework works, you can arrange whatever arrangement you want to arrange with your employee, as long as you document that. If you get into arrangement, you find out it doesn't work, you have the right to terminate that telework arrangement and say, look, telework is no longer working as far as we're concerned. If you want to come back, fine. Otherwise, we've got to explore some additional leave options for you because teleworking is not cutting. I think in some cases, employers have found out that that's the case. Same thing with intermittent leave. Intermittent leave is permitted, but only if the employer agrees to it. If you find that some form of intermittent leave for your employees' work, either under the Family First, the emergency FMLA or the emergency paid sick leave, you have the right to establish intermittent leave, but that has to work for you. The expanded leave expires on December 31st. We'll see about that. I'm not convinced.
Stu, I missed this question. Back to the daycare. Does it need to be a licensed daycare? What if it's a family friend or maybe even a family member?
That's a good question. I think it applies to any daycare. If it legitimately was a daycare that's not closed and available anymore, that would still be effective. Again, we might see down the road how the DOL interprets that through agency decisions or case law, but I think the documentation right now, if you legitimately had a family member, a grandma or a parent or someone who is providing daycare and they can't because of their own health situation or fear or whatever else, they're just choosing not to do daycare, I believe it would still apply. And I still think you need that documentation to make it work. To get that tax credit.
Thank you.
You bet. Somebody asked that, but here's my slide. Employers are required to post notice. That notice is not difficult to find on anywhere online. Just look at Department of Labor required notices to be posted for the expanded FMLA, and that posting will come up. Expanded leave pay is not available if the employer closes the work site, even if it is after April 1st. I think that's a given, but I have had that question and call from employers. What if we go out of business? Are we still obligated under these laws? The answer is no. If you legitimately go out of business, you close the work site where the employee worked, if you don't have work available to them, you are not obligated to provide that leave to your employees who would then be on furlough. We talked about this. Paid leave is not available if the employer furloughs or lays an employee off due to lack of work, even after April 1st. So remember, if you're laying off somebody, and this has happened quite a bit, if you've laid somebody off for lack of work after April 1st, and then once they're on layoff status, they say, well, now my circumstances have changed. Now I don't have daycare, or now I've contracted COVID and I need emergency paid sick leave. They're on layoff. Okay, so if they've been laid off already before they make a request for any available leave, they're not eligible for that paid leave. We're going to talk more about unemployment because I think unemployment has been a hot topic and it's all over the board. But here's the bottom line. An employee cannot receive unemployment benefits at the same time as receiving paid leave. So if they are receiving some sort of paid leave from the employer, they are not eligible for unemployment benefits. Okay, this is the second component of the Family First Coronavirus Response Act. And I think this one's a bigger deal, actually. Probably should have covered this first, only because I think this comes up more often. Under the emergency paid sick leave component of the Family First Act, employees entitled to up to 10 days or 80 hours of paid leave at 100% of their regular pay. This applies to an employee who is subject to a federal, state, or local quarantine or isolation order. Okay, we don't have that yet. Okay, remember, that would be a state order requiring an isolation or quarantine. We're not under that yet, haven't been. Or the employee has been advised by a health care provider to self-quarantine. The employee is experiencing symptoms of COVID-19 and is seeking a medical diagnosis. The employee is caring for an individual who is subject to an order described above. The employee is caring for a son or daughter whose school or daycare has closed. The employee is experiencing any other substantially similar condition determined by the Secretary of Health and Human Services. Okay, that last one does not apply yet either. But let's dissect the first ones that do apply. The first one that applies most often, employee has been advised by a healthcare provider to self-quarantine. Okay, what does that mean? That means an individual has gone to their doctor, either they've come into close contact with someone with COVID, and we all know circumstances where this has happened, and they have received a letter, a note, a script from the healthcare provider that says we're directing this person to self-quarantine for 14 days. That is a direction by a healthcare provider to self-quarantine. That triggers the 80 hours of emergency pay under the Emergency Paid Sick Leave Act. Now this, I've seen, this to me has been the biggest source of either controversy or concern is how to manage that particular issue. I reached out to the Community Health Center because I know the Community Health Center has been at the focus of some of this, some of these concerns that either people are negative or they really don't need to be on leave, but they go there and they somehow get a script that allows them to be off for a period of time, a week or 2 weeks. And what I'm told, and I think this is interesting, this comes directly from the Community Health Center. The recommendations from the CDC are that a direct exposure could develop symptoms anywhere between the 2-day to 14-day incubation period with this virus. All direct exposures have 14-day quarantine marked. When she says marked, she's talking about the form that they give to that employee that the employee brings back to you. Says, but there is a disclaimer at the bottom that says if they are an essential worker, their employee can have them return to work as long as they don't have symptoms and wear a mask. Well, that's confusing. It's confusing because as I read that, it says to me that based on that disclaimer, the employer has some discretion here. The employer, based on that language, would be able to tell the employee, well, you are an essential worker. You haven't tested positive. based on the recommendation from the community health center, we believe you're able to return to work. We would like you to return to work and wear a mask and social distance while you're at work. So then the question for the employer that I'm going to get is, well, do we have to, what if they say no? If they say, well, I'm not comfortable with that. I am not comfortable being declared an essential worker. I want to stay home for the 14 days. The question is then going to be for the employee and the employer, and for me, do we have to pay them for those 14 days? We're telling them we think they can come back. We think they can wear a mask. They can socially distance. And we think they're an essential worker to our business. We want them back here. So we don't want to pay them for that 80 hours because we think they can come back and work. I think the employer, based on that, has the right to do that. I think you've got the right to say, hey, you do not have a directive from your healthcare provider. In fact, your healthcare provider has said just the opposite. Healthcare provider has said that if you're determined to be essential, which we're saying you are, and if we have you wear a mask, which we're telling you to wear a mask, and if you can socially distance, and we're going to show you how to socially distance, we think you've got a directive to come back to work. If you say no to coming back to work, we're going to treat you as having refused to come back to work. And we're not going to pay you for that time. Employer, I think you have the right to take that position. Again, a little bit of guesswork on my part, folks, because we will see how this all shakes out. But if you just read what I've written there on that slide, employee has been advised by a healthcare provider to self-quarantine. I don't see that script, just as based I've read from the community health center, as providing that employee with a blanket directive to self-quarantine. Okay? So let's just play that out a little bit because I think this is how this scenario usually works out. So then the employee says, well, if I'm not coming back to work, I'm going to apply for unemployment benefits. We're going to talk about unemployment here more. Our workforce should be declining those employees for benefits because that will be a situation where the employee is refusing work that is available to that employee. I also think the employee will be denied benefits because under that scenario, the employee will not have a directive from their healthcare provider to self-quarantine. It will be a limited directive to self-quarantine. So then the employer says to me, all right, well, if they're refusing work, you know what, do I leave them on leave or what do they have available? What if they don't have any PTO? What if they don't have any available sick leave and they're just refusing to work? Let's say they're going to refuse to work for up to 14 days. What do I do as the employer? Well, that's a tricky one. I think the employer is now on their own in terms of how they want to exercise that discretion. I think a lot of employers are saying to that employee, fine, if you want to be home, that's up to you. We're not going to pay you for that time, but we expect you to be back in 14 days, but it's going to be unpaid. We don't think we're obligated to pay you. If that employee says, fine, I'll take that leave unpaid, that's how that scenario works its way out. There are, however, those scenarios where employer says, you know what, I said they're essential to begin with. I need them here. They're refusing to work. I need to fill that position with someone that can do that job. So what happens when employer says to that employee, I tell you what, you're refusing work. I'm going to treat that as a voluntary resignation of employment. We're going to replace you. I think the employer has the right to do that legally. That isn't discrimination. It's accepting a resignation from somebody who's refusing to work. I think we have to move beyond COVID and look at how we would handle that scenario under other circumstances. If an employee just came to you and said, hey, look, I know I don't have any paid leave, but I just want 2 weeks. I want to take a leave of absence. And it's just a personal leave, and I just want to be gone for 2 weeks. I know you've got work for me, but I don't want to do it. Employers probably in that scenario are going to say, I'm sorry, but that's not acceptable. We have work we need you to do. You're choosing not to do that work. we're going to either have to let you go as a voluntary quit, or you're going to have to continue to do that work. Employee says, I'm not going to do that work. Under most scenarios, employers are going to accept that resignation, or they're going to grant the leave, but they may very well tell that employee, we're treating this as a voluntary quit. You're refusing work. In that scenario, there's no question that the employer would be within their right to make that decision that the person is declining work, refusing work, and not wanting to come back. So I look at this the same way, and I think the employer would have the right to determine that that individual is refusing work. And if the employer chooses to, not saying you want to or will do this, but I think that employer could exercise discretion and replace that employee on the job. So that's a question I get a lot of times, and I think that's complicated. I think every employer is doing that different. I know right now, maintaining your labor pool is an important piece of the puzzle. So I think a lot of employers are going to choose just to work with that employee. But to the extent you're asking me from a legal standpoint, what if we want to move on from that employee? Can we? I think the answer is absolutely yes. Let's go down to the next one. Employees experiencing symptoms of COVID-19 and is seeking a medical diagnosis. Okay, if they're experiencing symptoms of COVID-19, that is a basis that triggers the emergency paid sick leave. But remember, they have to be seeking a medical diagnosis. In situations, I know employees have said, hey, I'm experiencing symptoms of COVID-19 and I'm going to stay home and I want the emergency paid sick leave. Okay, here, to get that tax credit, to really come within the law, they have to be seeking a medical diagnosis. It's not enough to just say I'm experiencing symptoms. Okay, Stu's got a cold today. And by the way, I did have COVID in August. So speaking from a little bit of experience, I have a symptom of COVID. Now I know nobody wants me at work anyway. If I've got some symptoms, we all want me staying home. But to trigger the Paid Leave Act, I need to be seeking a medical diagnosis. I need to be making an appointment with my doctor. I need to be running over to Community Health Center for rapid testing. If I'm not doing one of those things, I have technically not triggered the Paid Leave Act. Okay? So if that's the case, you need to make sure you're telling your employees, all right, you got symptoms, go get that medical diagnosis. And then we get into the next scenario that often they go and they test negative. But sometimes when they're testing negative, they may still be directed by their healthcare provider to self-quarantine. If that's what ends up happening, that would still trigger the paid sick leave unless there's that disclaimer that says, unless they're an essential worker, they can come back to work. So you've got a few different ways that could work its way out, but it's all going to be triggered by their medical diagnosis. Did they test positive? Did they test negative? Obviously, if they test positive, we know we've triggered the Paid Sick Leave Act, and the employer has an obligation to pay them for that time.
Stu, we have a question. What if the employee is sick for a week, then is diagnosed? Should both weeks be paid under this?
So in other words, the employee is just homesick on their own for a week, and then they go get their medical diagnosis after that. Is that what you're thinking that means, Kelly? I think.
Yes, Stu, that I was the one that asked that question. The person's sick for a week at home with symptoms, but not going to the doctor. Second week goes to the doctor, gets a positive diagnosis.
I think that's enough to trigger the paid sick leave. I guess your response might be, well, they didn't go get the diagnosis right away. So does that relieve us of the obligation to pay them those 80 hours? I think not. I think if they're home, a reasonable person would say they stayed home because they had the symptoms, and then they did get that medical diagnosis. Even if it wasn't spontaneous, they did at least get that medical diagnosis, tested positive. I think they've done enough to trigger the 80 hours.
I see that Kelly stepped away. There was another question saying, regardless of how many times they tested positive, total pay is only for 2 weeks.
That's it. That's exactly right. So, yeah, interesting scenario if you play that out. Yes, they're only going to be eligible for 80 hours, and you're only going to recoup through the tax credit. You're only going to be able to recoup up to 80 hours. But yes, you could have a lot of scenarios that that happen after that. I will tell you, we probably all know circumstances where somebody's been ill for longer than 2 weeks. I mean, sometimes people have been hospitalized for 3, 4, 5 weeks. So what do we do with that additional time? There is no law that impacts that. Now you're just dealing with somebody who has an illness. It's not covered by the coronavirus family first, whatever. I had tired of saying that word, but it's not covered by family first. They are just somebody who's ill and not able to return. And let's just get into that, even though I've got a slide that covers that. Now, in my opinion, they are likely somebody who would be covered by the ADA, okay? Now you've got a potential disability. You've got somebody who's got a long-term illness. I think now you're looking at what is a reasonable accommodation. You've got somebody who's sick, unable to return. How do we treat that employee? Well, if they've got paid leave available, that's triggered. Let's say the FMLA. Now, if you're an FMLA covered employer, that would certainly trigger the serious health condition requirement for eligibility under the FMLA. So let's just say you are an FMLA covered employer, and that individual took their 2 weeks, they got their 80 hours of paid leave, and they're still in a hospital or they're still unable to return to work. I think you're reaching out to that individual just like you would with anybody else who has a serious health condition, and you're saying to them, hey, why don't you get the healthcare certification form completed? I think you're eligible for FMLA. And they're going to get that form back to you. It is going to tell you that they have a serious health condition. Now they're eligible for up to 12 weeks of leave, okay? Not the expanded leave, but the traditional FMLA. Obviously, for those employers who are not covered by the traditional FMLA, it is a different analysis. But for those that are, you're looking at traditional FMLA for those people that have to be out for an extended period of time. Let's say they don't have FMLA available to them, okay? They've exhausted their FMLA, or they never had FMLA to begin with because you're not a covered employer under traditional FMLA. In that scenario, we're dealing like we would with anybody else who's unable to work because of an illness, okay? The employer now is in that area of they're going to have to exercise discretion. Do we want to grant them a leave of absence? Do we have to fill this position? All those things you consider for employees who are just out for an extended period of time without any type of available leave, okay? Is this something that's going to be covered by the ADA? There could be some ADA interaction here. Do they now have some sort of a disability that we need to accommodate? I don't know the answer to that. But I think one thing we do know under the ADA is the ADA does not mean you have to continue to employ somebody who can't do their job. So what does that mean? Coldly, it means this. Legally, if they're out 4 weeks, okay, you're not a covered employer under the FMLA. Yes, I think you have the legal right, should you want to do it, to say, I'm sorry you've got that condition. I'm sorry you've got that illness. We need that job being done. We need to find somebody who can do that work. We're going to have to let you go. When you recover, when you're fine, please come back. When we have an opening, we'd be happy to bring you back to work, but we've got to move on from you right now, and we've got to replace you with somebody that can do the job. That's still the legal analysis that we've always talked our way through with the ADA, and it still applies once they've exhausted available leave under the Family First new opportunities for paid leave. So again, I'm not looking at you to see how many of you are totally confused by that, but I think that is the analysis. We still have to look at the ADA like we always have in the past. We still need to look at the FMLA like we always have in the past. And if none of those apply, if the new law doesn't apply, we're still going through that analysis like we have in the past. The one difference here is I think there's a different sense of accommodation right now. When I'm talking to employers, a lot of employers are granting leave they've never granted before because of the concern for the workplace, the concern for the labor pool, the desire to keep people on the payroll, keep people working when they can get them back to work. So I get all that, and that's perfectly right. It's the right, maybe you believe the fair thing to do, but from a legal standpoint, let's still look at the ADA and the traditional FMLA when other types of available leave under the Family First are no longer available.
Stu, I have a couple questions here. Regardless of how many times they test positive, total pay is only for 2 weeks, or they lose their daycare or what have you?
Yep, and Kel, I think, Chris, is that the question?
Yeah, we answered the first half of it. The or later lose daycare part came in after I asked you that question.
Okay, thank you.
Okay, remember the daycare part, they could use their 80 hours, okay? They can use their 80 hours under the emergency paid sick leave. And if their reason for taking pay was under the emergency paid sick leave, that would pay them at 2/3. They still have an additional 10 weeks under the emergency FMLA. If their reason for being gone is then related to school or daycare closing, because that's a 12-week bank of time. Okay, so they have 12 weeks if that's the reason for their leave, assuming they have FMLA available to them. Okay, if they've exhausted their FMLA already, okay, available FMLA they've already used 12 weeks for their own serious health condition. Maybe they did that 6 months ago. They don't have any more time left. Then they don't get any additional time under the expanded FMLA, okay? But if they haven't already exhausted FMLA in the past, then they would have 12 weeks available to them, 2 weeks of emergency paid sick leave, and additional 10 weeks of leave available to them if they have to continue to be home to care for a child because the child's school or daycare closed, okay?
Okay. I have 2 more questions now. Is notification of expanded FMLA and the traditional FMLA different? And do we only have to comply with the expanded if less than 50 employees, or does that trigger the full FMLA?
Do that for me one more time, will you? I'm sorry.
Oh, okay. Is notification of expanded FMLA and traditional FMLA different? And do we only have to comply with the expanded if less than 50 employees, or does that trigger the full FMLA?
The notification is the same, okay? So you're going to want to do the same notification. For those employers that aren't covered under the traditional FMLA, you're going to now want to provide the same notification. So it's the same notification to employees, whether we're talking about the expanded FMLA or the traditional FMLA, okay? So that part of it is, and Kelly, give me that second one again. I got my brain going too many directions. So what was the second?
No, you're getting really excited, Stu. And do we only have to comply with the expanded if less than 50 employees, or does that trigger the full FMLA?
No, only the expanded. I mean, if you're less than 50, you're only caring about this new expanded FMLA. If you're less than 50 employees, nothing has changed for you as it relates to that traditional FMLA. Okay, all those reasons for an employee being entitled to coverage under the FMLA, they don't apply to you. Okay, you never have to worry about that if you're a smaller employer with less than 50 employees. You're only caring about this expanded FMLA. which only applies to someone who has to be home because to stay with a child whose school or daycare closed.
Okay, I have one more question here. What if the employee is sick, they are terminated due to an extended illness or due to an extended illness? Would they then be eligible for unemployment? They aren't able to work. The posting notices are different for, oh, sorry. That's another question. Sorry, Kristen.
I think I got that first one. The answer is no. They would not be eligible for unemployment under state benefits. And this has been complicated. And it's not Iowa Workforce's fault. I don't mean that at all. But because the pandemic unemployment assistance came into play, there's real confusion out there over eligibility for unemployment benefits. So under that scenario, if an employee is let go because they're ill for an extended period of time, they are not going to be eligible for what I will call traditional unemployment benefits from the state of Iowa. The reason they're not going to be eligible is because they're not ready, willing, and able to work, okay? Unfortunately, their illness prevents them from being ready and able to work. Consequently, they're going to be denied unemployment benefits. But under the federal pandemic unemployment assistance through the CARES Act, they would be eligible for up to $600 per week of federal unemployment benefits because their reason for not being able to work is related to the pandemic. Okay, it's a different standard. So a lot of employees and employers have seen weird rulings from Iowa Workforce Development that they just don't understand. Either employees are being found eligible or they're not being found eligible. And the bottom line is, if the reason they're not working and their separation is because they're not able to work, they're not going to be eligible for those traditional state unemployment benefits. They don't have to reapply for these pandemic benefits. Their claim is automatically triggered, okay? And Iowa Workforce automatically evaluates their claim based on this Pandemic Unemployment Assistance Act. So they may very well be denied state benefits, and then they may get a decision that says they're eligible for federal benefits. My daughter's a great example. I've got a daughter who was unable to work because she's got Crohn's disease. So she filed for unemployment benefits because she was told by her doctor, don't go back to work because of your Crohn's disease. I just don't want you doing that. And she was denied state unemployment benefits. But it automatically triggered her application for federal benefits, and she was then awarded federal benefits. So that's happening a lot. And I think I answered your question. If not, tell me.
Yeah, and then there, the follow-on question, the posting notices are different for the expanded and regular FMLA, right?
Yes.
Okay. And then I have one more. When does the 2/3 pay come into effect and we have to pay for the 10 weeks? Division C, I'm not sure what that means.
Okay. The 2/3 pay comes in whenever their reason for being gone is related to a need to be home with their child whose school or daycare closed. Whether it's under the, and that is actually triggered by the paid sick leave. And this is where the two laws kind of combine. But under the emergency paid sick leave, that would trigger the pay at 2/3 the pay if their reason, and let me see if I actually have a slide that says that. The employee is paid 2/3 of the employee's regular wage if the reason for paid leave is related to school or daycare closing, okay? So if that's why they're gone, that's 2/3 of their pay. If their reason for being gone, I don't know if I might have to go back a couple. If the reason for being gone is, in this slide, employee has been advised by a healthcare provider to self-quarantine, or the employee is experiencing symptoms seeking a medical diagnosis, that's 100%. Okay? So those are the circumstances you're going to pay 100%. If the reason is they need to be home due to a child, that's going to be paid at 2/3. And that's the only one that is paid out for 12 weeks. Okay? If it's due to your own condition, your own situation, that's where you're going to get paid at 100% just for 80 hours. Did I cover that, Kelly? Are you reading another question?
Oh, I'm responding to another one. Yeah, I think so. I think that.
Okay. Should I keep going, or do you have another question?
No, go ahead.
Okay. Again, dealing with this paid sick leave, no employee requirement to have worked a length of time. So an employee is eligible for that 80 hours day one. Unlike the other one, the expanded FMLA, they must have been working for you for 30 days. Under this paid sick leave, you may not require the employee to use other paid leave before you pay out that bank of 80 hours. Okay, that's first. That's priority number one. You also can't make the employee make other arrangements. What does that mean? You can't say, before we pay you anything, go find somebody to work for you. You've got to find somebody to fill in for you. Then we will pay you to be off. You can't do that. No carryover of unused time and no payout of paid sick leave. In other words, that 80 hours, that doesn't carry over. You can't say, well, you know, now I used half of it, so I want to use half down the road. It's paid out one time and that's it. Doesn't get paid out. Let's say somebody terminates employment. It's never subject to payout at the time of separation of employment.
Okay, I have another question that just popped up. Division E is if somebody is actually sick, paid at 100%. Division C is if school or daycare is closed, no one is sick, paid 2/3 wages. Question.
Yes. Was that a yes, no?
I think so.
Okay. I kind of covered the interaction here with the ADA. And just a couple other little things. If you're a small business that has exempted yourself from coverage, then obviously you don't need to post the notice that's required under the Family First. And this last one comes up a lot. Employer can elect at its discretion whether an employee is eligible for PTO because the employee chooses not to work out of fear of contracting COVID-19. And this jumps right into the unemployment conversation. And again, since I can't see any of you, I can't tell how many of you folks want to stay with this topic, if you want me to jump into other employment stuff. But so just tell Kelly if I'm wasting your time and you want to move on. But this is one thing that does come up a fair amount of time is if somebody is just telling you they're fearful, and this happens a lot. I don't have a reason to not come to work. I haven't tested positive. I don't have symptoms, but by golly, I'm not comfortable, man. I see what's going on. I've heard we might have some people test positive up there, and I just don't want to be around that right now. So I'm going to stay home and use my PTO. They may be able to use PTO. That's going to depend on your own policy. Generally, if they can use PTO for any reason without explanation, sure, they can use their PTO. But let's say it's sick pay and they want to use their sick pay. Do they qualify under your policy to use their sick pay or their vacation pay? If the answer to that is yes, then you can allow them to use that. But there may be scenarios where you say, your fear and decision not to work does not trigger our obligation to pay you for there's no paid leave here. Every employer is going to have to wrestle with that scenario on their own because there is no real good legal guidance there. We've done this.
I have another question for you.
Yeah.
If you took PPP money, are you disqualified for the payroll tax credit?
No,
If you-
not at all. Two
Okay,
separate laws.
Okay. And-
The PP money was under the CARES Act, okay? And it's a whole different set of qualifications to be eligible for those benefits, but it has nothing to do with your eligibility. And I think employees confuse that too, but it has nothing to do with your eligibility for that tax credit for compliance with the Family First. And I've had a number of employees call me and say that things like, my employer is telling me that they won't grant me leave. I don't want to work right now. I'm in fear of working. My employer is telling me they won't grant me leave. And that's illegal because I know they got PPE money and they can't do that. That's not true at all. Okay. The PPE money that came out in April, okay, and many people applied for and received those dollars. That has nothing to do. It did require you to maintain your payroll for the next 60 days following your receipt of those benefits, but maintaining that payroll did not apply to particular employees. It applied to your total payroll. So during that 60 days, I know there were there was a flux in who you were employing. You might have let 2 people go, added 2 more. Your obligation was to maintain your payroll. It didn't obligate you to keep any particular employee employed. I mean, that would be nonsense. Somebody steals from you and says, well, you can't let me go. You've got you got PPE dollars. That's not the obligation. The obligation was to maintain your payroll for that period of time. But the short answer to that question was no, there is no connection between the PPE dollars and your ability to get a tax credit.
Okay, and if you've used all of your PPP per the loan agreement, and it's now coming from your operating expenses.
What does that mean?
I read that direct. Let me see if I can get a clarification.
Okay, all right. Before I leave the topic, unless people start telling Kelly we want out of here, unemployment. A few things that I think are worth noting, and I just highlighted for my workforce some of the positions they've got on matters, and they do a nice job in some of their outlines of explaining their position if someone's eligible or not eligible for benefits. But one that comes up, if an employee receives unemployment benefits as a result of COVID-19 related business shutdown, will our employment taxes increase? Remember, the nice thing right now about claims that are related to COVID, if they are legitimately claims that are related to COVID, your account's not being charged right now. So if somebody is off related to COVID and they filed for unemployment benefits and they receive those unemployment benefits, you're not being taxed. At least through December 31st, you're not going to be taxed. That was part of $1.25 billion that Iowa was awarded through the CARES Act. And that is funding all of these unemployment claims that are related to COVID. So in some cases, that relieves some of the anxiety about some of the unemployment claims you're having to contest or not contest. And I think it's made a difference in the number of claims that employers are contesting. Some employers are choosing not to contest claims because they know they're COVID related and they know they're not getting charged. Other employers I've talked to said, well, it's still not right. We're still going to contest that claim and see the process through, even though it's not being charged on our account. That's an employer decision. You've got to decide. But at least through the end of the year, these claims are not being charged against your unemployment account. Another question that's asked is, can I require a worker to stay home for COVID-19 incubation period? The answer is yes. You always have the right to require an employee to stay home if you want to, okay? You can say to that employee, we're not comfortable, you got some symptoms, go home. They say, I'm fine, these aren't symptoms, I'm not sick, you have the right as the employer to send them home. Now, they will be eligible for benefits in that scenario, okay? If they say, fine, but I'm going to go apply for unemployment, they can receive unemployment in that scenario. So know that going in if you want to send them home, but you can send them home. The other topic that comes up is what can we do for testing? Until the pandemic, there was a real limit on what sort of medical tests, temperature tests, other types of tests you could require of your employees. The EEOC has significantly reduced any penalties or prohibition against testing of employees. So right now, if you want to conduct tests for every day for your employees, you can. You could, if you wanted to, require your employee to go get a rapid test every day before they come to work. Okay, I don't think employers are doing that, but my point is you can implement a testing protocol if you want to right now during this pandemic to try to keep your workforce safe and healthy. I covered this, but I think it's good that Iowa Workforce covered this as well. Is fear or a non-documented reason enough for a worker to not be at work? And can they draw unemployment benefits? The answer is no. If they're just afraid and don't want to come to work, they're not eligible for unemployment benefits. Now, this seems like a good time for me to discuss an issue that's come up a lot. I'm defending about 66 OSHA complaints. And most of these OSHA complaints from a variety of employers have come up the same way. They're employees who are sensitive to COVID in the workplace, and they're telling their employer that, hey, this doesn't look safe to me. I don't like the social distancing that's happened in the office. I don't like the fact that some employees are not wearing masks because there is no mask mandate in employer settings. And I just don't think it's a safe environment. And I think you're making me come to work in an unsafe environment. And the employer says, look, we've worked with public health, or we think we're following CDC guidelines, and I'm sorry, but that's the way it's going to be. And the employee either quits or the employer says, well, I'm not coming to work. And because you're not providing a safe work environment. And as a result of that interaction, the employee is then filing a complaint with OSHA. And let's say what happens is an employee says, I'm not coming to work, and employer says, well, I've got to replace you then because you don't have any symptoms, you haven't tested positive, I've got to replace you, I've got to have someone to do the work. And they replace that employee. That employee is then filing a complaint with OSHA, and the complaint is, I was terminated in retaliation for expressing my fear about the work environment. And OSHA, I'm telling you, is aggressively defending these claims. And I think it's a little bit disingenuous for OSHA to be treating these as valid claims when the employer is following the law in all the CDC and public health guidelines. But nonetheless, OSHA is aggressively following up and investigating these claims by trying to determine if the employee was actually retaliated for expressing a concern about workplace safety. And it's my position that no, that's not why employee was let go. Employee was let go because they refused to work. And they wouldn't do their job, and employer economically had to replace them to make sure the work was getting done. But there's a real rub, and OSHA has not been definitive yet in how they're going to rule on cases like this. But I just warn you of that. And I think the message here is, if you have that scenario, continue to communicate with your employee about the reason they're not working. And if you actually have to terminate or separate that employment relationship, I think it's very wise to follow up in writing to make sure we're letting you go solely because you're refusing to do work that we have available to you. And I'm sorry, but we've got to have this work done. And when you're able to come back to work, when you choose to come back to work, we will welcome you back as long as we have work available at that time. We're not terminating you because of anything you did wrong. We're just separating with you because you're choosing not to work, and we've got to have somebody that can do that job. I think that paper trail is going to be an important piece of paper for OSHA, because if you get one of these OSHA investigations, they're time consuming and they're risky. If OSHA were to determine that you did retaliate, there's significant monetary consequences. It could be a bad deal for you. You have any other questions on unemployment or anything else that's come in?
Nope, you're clear as mud to me.
Yeah, clear as mud to me too. Okay, I'm going to jump off this and just move on with my slides, just so we don't spend this whole time talking about COVID. Not that I mind talking about COVID, but there's other things that we traditionally try to talk about here. So I'm going to move into that. See, and if people, hey, as we move on, if it triggers other questions regarding COVID, I don't care a bit. So.
Before we do move off COVID, we did have one question in the really beginning. When do we stop taking temperatures? I think, Kristen, that was your question. If you need to clarify or want to add anything.
Just, you know, with trying to follow with the OSHA regulations and things such as that, you know, providing a safe workplace, you know, taking temperatures, pre-screening questions, things such as that. What are your thoughts on that?
To me, the answer to that is the EEOC will tell us when that changes. The EEOC affirmatively came out and relaxed those testing requirements to allow employers to test. I think the EEOC will go back and undo that when they think it's time to undo that. Whenever this pandemic ends, I think until everybody's comfortable that the pandemic is past us, the EEOC will allow that testing. When they think it's time to go back to the way we were, they're going to let us know. So for now, in the foreseeable few months, I think that testing is just fine. Anything else you want to talk about right now on COVID? Okay. Then these slides, I'm going to continue to work my way through. Some I'll spend more time with than others, but again, just throw in a question when you've got one. Statistics, I'm just using a slide I used last year that just shows the number of complaints, and I always like to highlight for employers the amount of money that it takes to resolve a complaint. That dollar amount's only going to go up. And everybody says, well, how can that be 104 grand? Well, by the time you hire a lawyer to fight one of these claims, employment claims, and maybe you pay out some settlement and you pay attorney's fees to the side, that's an average, 104. I got to tell you, some of these that I've seen lately, that's on the low end. So just a reminder to employees of the cost of doing business when it comes to employment laws. Again, this is just really review state and federal discrimination laws. You know, a couple things that I want to highlight in here is the 300 days to file. I know you all know this, but an employee who feels aggrieved under any of our civil rights laws has 300 days to make that complaint. I'm seeing an emphasis by employees sometime to come within that 300 days when they don't really fall within that 300 days. There's talk about even relaxing that further. It used to be 360 days and they dropped it to 300 days, but I think they may go back to 360 days. Kind of depends who's making our laws right now as to which way that travels, but keep in mind that it's a 300-day window. So anytime you've got someone making a complaint somewhere of discrimination, they've got 300 days to file that complaint with an administrative agency. Okay, this again, I'm just reminding you of our Iowa Civil Rights Act jurisdictional issue. If you're an employer that employs 4 or more employees, you're covered. So if you're a really small employer, you're not going to be covered by our state discrimination laws or our federal law, because the federal law is 15 employees. You may escape responsibility and liability for civil rights discrimination decisions just because you don't meet that minimum threshold of employees. Age discrimination, remember, is age 70 under the federal law. Under the state law, it's forever. And even though I probably have a slide, I'll just touch on that now on age discrimination. This is going to be a bigger and bigger problem because when something like a pandemic hits, people are less inclined to retire. They need to work longer. And as they need to work longer, they want to stay in their jobs longer. When they want to stay in their jobs longer, it sometimes can create a stress for employers. I know a number of cases within the last year where employers have called and said, hey, I was working with Stu, and Stu told me that he planned to retire, and gosh, we put the wheels in motion. You know, Stu's 66, and it's, you know, he had everything in place to retire, but now he says due to the economy, he's got to keep working. Man, we really had someone already in place to come in and take that job. And we've kind of ignored some of Stu's performance issues because we knew he was going to retire. Now he says he's not going to retire for a couple of years because he's got to get his finances in order. What do we do? Well, that's a real dilemma because there is no top end. Let's say Stu happened to be 72-year-old. Okay, there's still no top end under our Iowa civil rights law when I can file a discrimination complaint. I can be 70, 79, 89 and still file a claim for age discrimination. But in that scenario, I think employer has a responsibility to tell Stu, hey, look, we already had this greased. You told us you were retiring. I'm sorry, but we took steps to accept your resignation. We now need to hold you to that. We've already placed somebody. We've made arrangements. We've got somebody hired. We can't go back and change that now. So we're going to stick with our plan that you were going to retire. And we hope that's good by you. But if it's not, we will have to move you out of that position. Okay? That's legal. Stu's not going to like it, and it creates a potential for controversy. But I think through establishing your plan that was in place already, you can survive that claim just because you already had the wheels in motion. But those are dilemmas, remember, with older employees that I think you're going to see more and more. People are just working longer. I don't see anything earth-shattering here talking about the Federal Civil Rights Act of 1964. The only difference is it only applies to employees with 15 or more employees. Sexual harassment, I talk about this every year, but it's still surprising to me. The Me Too movement, folks, is not done by any stretch. If you happen to read today's Fort Dodge Messenger, you saw an unfortunate situation in a school district down south of Fort Dodge that had a staff member who was forced to resign because of sexual harassment. And I just made particular note of the article. It talked about the term Me Too came up, where once the individual came forward with concerns, there were others that felt empowered to bring those concerns, and they referenced the Me Too movement in the paper. I think that's an example of what we're still continuing to see. Sexual harassment is not going anywhere. I mean, it continues to be a surprising concern. I say surprising because some of the scenarios that we encounter just seem dumb. I mean, I'm just blown away by some of the poor actors who just don't appreciate sexual harassment or literally just do not care what sexual harassment means. So again, just a reminder to, don't stop your due diligence and training on sexual harassment and continuing to remind people what is and is not acceptable. Continue to remind your managers of the critical importance that when they see something, they speak up. There's almost always a fact pattern with sexual harassment that somebody knows about it and somebody chooses to ignore it. A manager knows about it, turns a blind eye. A supervisor sees it every day and just gets comfortable with it instead of recognizing the fact that it's sexual harassment. It's the boys will be boys mentality. And, and that sounds sexist because there certainly can be sexual harassment the other way. Frankly, we just don't see a lot of it. I know it happens. We just don't see a lot of it. So I don't tend to highlight reverse sexual harassment, if you will, even though I know it's out there. But it is generally, in my experience, the same old scenario where a manager will say to me when I go to investigate a claim, well, why didn't you deal with Bob? Everybody knows Bob. He's a nice guy. He's a jokester. Bob is Bob, and boys will be boys sometimes. And, folks, you just got to get used to it. People need to have a little thicker skin. And by golly, everybody can't be so sensitive to what Bob says. He's a good worker. Well, what I tell every organization is that's a business decision. If you want to continue to employ Bob because Bob makes you a lot of money, I get it. And sometimes, frankly, that is the response. We can't let Bob go. He's valuable. He's got a lot of contacts. He's well known within the community. And doggone it, if we let Bob go, there's going to be serious financial repercussions. And my response is always, that's fabulous. I completely understand. As long as you don't mind paying me and mind paying the other lawyer and mind paying all the people that he sexually harasses because you've weighed out the financial pros and cons, you got that figured out. Bob's perfect. We'll just deal with the claims as they come up. That's a business decision, okay? But I do get that, and I think we all need to be mindful of that. Sometimes it's easy to relax in an atmosphere where there's there's just some casual, relaxed atmospheres, and it becomes flippant. And I get it. People work around each other. They tend to make comfortable comments that maybe are not appropriate if we were walking or talking on the street. Just be mindful of this. If someone complains, do something about it. I never tell organizations that you have to go in and police everything that everybody says, because every work atmosphere is a little bit different. But just remind yourself, if somebody complains, don't ignore the complaint. If you deal with the complaint when it happens, you investigate it and take some sort of action, you're almost always going to be okay. So that's my message on sexual harassment today. Age discrimination, we already covered this. The only added thing I want to talk about is down there at the bottom, waiving age discrimination complaints. A lot of employers, when employees separate, they will create that standard release form, and they'll have an employee sign, we're going to pay you 3 weeks of wages. We ask that you sign a release of any and all claims. If you have the practice of doing that, that waiver, if you really want a waiver from an age discrimination complaint, it's a whole different type of release. There are about 5 or 6 language pieces that must be included in a release of an age discrimination complaint that does not need to be included in the release of any other type of complaint. So if you've got an older employee who's separating and you think a severance agreement and a release is a nice tool, and it is a nice tool, you're going to want to make sure that you comply with the requirements of the Older Worker Benefits Protection Act, and you have the necessary language to get a release from that age discrimination complaint. Well, the FMLA, seems like we've kind of been talking about the FMLA all day, but we really haven't been, because we've been focusing on the expanded FMLA. This is just a reminder, again, of the traditional FMLA. And I know that those of you that are probably listening in, I don't know what percentage might be covered by the FMLA, probably not half, because it only applies to organizations with 50 or more employees. There really is nothing new with the FMLA that I wanted to bring to your attention if you've heard this presentation before. But this is just kind of a reminder of those FMLA obligations. And maybe if you are a larger employer and you've never heard this presentation before, you've never really heard anything on the FMLA. But the FMLA essentially provides 12 weeks of unpaid leave, okay? So this is a traditional FMLA we're talking about, not that expansion of FMLA that would grant that person 2/3 of their pay for the 12 weeks. Under the traditional FMLA, it's always been unpaid leave, okay? Birth or adoption of a child, or primarily due to a serious health condition, either a serious health condition of the employee or a serious health condition of somebody that the employee needs to care for. That would trigger the FMLA obligation in the 12 weeks of available leave. There's also additional leave rights for those individuals that need leave who, due to military concerns, they actually can get up to 26 weeks leave to care for an employee's spouse, son, daughter, parent, or next of kin who's a current member of the armed forces with a serious injury or illness. Okay, so I'll just let you look at that screen. I don't really have anything else that I think I need to add today on the FMLA, because there really has not been changes to the FMLA. It's still the same eligibility rules apply. I always like to do a reminder of the anti-retaliation provision. This always comes up a few times a year from employers. Once somebody takes that FMLA leave, remember that changes their at-will scenario a little bit. I'll call it at-will scenario. Technically, yes, those people are still at-will employees, but you have to be mindful of the retaliation concern. If Stu takes FMLA leave, I'm released tomorrow to return. My FMLA expires, I come back. The day after my FMLA expires, and you take that opportunity to cut me loose, that looks like retaliation, and you're probably looking at a lawsuit for retaliation under the FMLA. What sometimes happens in this scenario that I found is, in Stu's absence, you realize you really didn't need him to begin with. He'd been gone for 12 weeks, you didn't miss a beat. 12 weeks went by and you go, geez, Louise, we wouldn't even know he was gone if he didn't say he wanted to come back. He added nothing, and we found out in his absence that that's a position we can easily get rid of and we won't miss a beat. Well, the problem is, once I return, you better then put the wheels in motion to eliminate my job. Then you're going to want to put together a game plan. You're not going to want to do it on the eve of my return. Even if you know in the back of your mind that we now know we don't really need that position, you're going to have to jump through some hoops before you just let me go and eliminate my position. What I would suggest you do in that scenario is put together an internal game plan. Do a review of the needs of that position. Get some other buy-in from other management employees and put together some sort of a documented plan of action where you make a legitimate decision that you can afford to downsize Stu's position and eliminate that position or let him go. Give that 2, 3, 4 weeks. You know, Stu's now been back for 4 weeks. You've got a plan in place that says we didn't need that job to begin with. We learned that in his absence. Now we've made a business decision to let that position go. That looks good, okay? Just be mindful of the anti-retaliation provision so you're not letting me go the day I come back from work, from leave. I don't really have anything new to add on the healthcare certification form. I think that is review for almost everybody. I don't think there's anything there in that slide that's going to be earth-shattering to anybody. People always call me and are disappointed. Sometimes with healthcare providers, believe that healthcare providers are just too relaxed in indicating that somebody's got a serious health condition. What can they do about that? My answer is always pretty much the same, not much. If that healthcare certification says that Stu's got a serious health condition, you can challenge that. You can you can have a second opinion done. If the second opinion is different, then you can mutually agree to have a third opinion done. For the most part, you're kind of jumping down the rabbit hole. There's not much there. I would say to you, if a healthcare provider says Stu's got a serious health condition, for the most part, you've got to live with that. You can ask to have recertified down the road, but that's generally not a fight you're going to win. I'd like to talk about the interactive process that's highlighted here. The ADA requires interactive process. I remind people that a number of years ago, Once the 12 weeks was up, it was pretty automatic under the FMLA. An employee was out for 12 weeks. Once they were out for the 12 weeks, the first day they couldn't return, you just sent them a notice saying, your 12 weeks are up, you're not back to work, sorry, we got to let you go. The ADA says that no longer is permissible. The ADA now says you have to engage in the interactive process. What that means is you've got to reach out to that employee and you've got to have some conversation or some understanding as to why the employee is not coming back to work. Because if the employee tells you, well, sorry, I'm not back today, I'll be back tomorrow. I had to go to my doctor today to get cleared. It's considered a reasonable accommodation to grant Stu that additional day. On the flip side, you reach out, employee says, yeah, this turned out to be much worse than I thought it was. I'm going to need another 6 months off. Well, that's not reasonable. You then have the right to make a determination that granting an additional 6 months of leave just doesn't work. We've got to make an employment decision. We've got to move on. That's what the ADA now requires, the interactive process, just so you know if there's some sort of reasonable accommodation. Discharge is my next topic. And I highlight discharge really more than anything else because almost all of our employment concerns, litigation arises from the discharge. I am defending one that arises out of a suspension in a long-term care facility way over in eastern Iowa, and I don't really get that. Somebody filed a civil rights complaint because they were suspended for 3 days. I mean, we're essentially fighting over $150, or I don't know what it is. I don't mean to minimize that, but it is unusual that you're seeing civil rights complaints arise for something less than a discharge. So what I remind employers is, yes, you want to be responsible to all of your employment decisions, all terms and conditions, your hiring decisions, your promotion decisions, your pay decisions. You want to pay people fairly. You don't want to discriminate in your pay arrangements. But you really need to pay attention when you're exploring a discharge scenario because that is where the likelihood of litigation comes up. You know, the documentation is really important. Documentation to support legitimate business reasons. I always bring up the fact that I've got a few employers who will still, when they terminate somebody, they will tell the employee, I don't have to give you a reason why I'm letting you go. You're an at-will employee and we're not going to give you a reason. That's never a good practice, even though technically you're right, it's legal. If you tell somebody that, they always think that you've got some illegal motive for wanting to let them go. And if they can't get a reason from you, their next step is to go to their lawyer, and they ask their lawyer to get a reason. And once their lawyer is involved, they start exploring whether they've got some sort of a legal claim arising out of the separation. So I think it's a much better practice to be as candid as you can. I tell employers, don't go into a lot of details during that exit interview, but don't mind telling an employee, you know, I'm sorry, your performance was just not cutting. You know, we tried to counsel you. You know, we talked to you once in the past. I think we have at least one written reprimand regarding your performance. At this point, we just don't see you having a bright future here. Rather than continue down this path, we've decided that it's not a good fit. You don't have the skill set we're looking for. Sorry, we have to tell it to you like that, but that's the way we see it, and we've got to move on. Employees don't always like to hear that. It's not always the easiest conversation, but at least you've provided a legitimate basis for wanting to make that decision. Okay? Don't ever tell an employee something that's not true. I've got a claim right now with some organization down in southern Iowa, and I will tell you, she made repeated complaints about sexual harassment. 3-4 times. They were ignored. 2 days after she made the last complaint of sexual harassment, the administrator called her in and told her they were going to let her go because of her attendance. Well, she'd never once been reprimanded about her attendance. She'd never once been even counseled about her attendance. In fact, all the documentation that we can see would indicate that she never had an attendance problem. Her attendance was better than her coworkers. So that's a killer. And it's also a killer that they've well documented the fact that the reason they let her go was attendance. You can't wiggle out of that. Okay, once you've laid that out in writing, you're stuck with attendance. And if attendance turns out not to be the reason, you can hire the greatest lawyer in the world to defend your claim. You're going to pay out money. So employers need to be mindful. Establish from day one, what is our reason for separation, and be prepared to stick to it. Okay, it doesn't change. Got a slide that talks about civil rights complaints, but I'll talk about that right now. Same thing when you get that civil rights questionnaire, and most of you have had that experience at least once or twice. Take your time with that questionnaire. Do your analysis and investigation before you ever submit that questionnaire, because once you submit that questionnaire and you explain the reason for separation or the action you took, you're stuck with it. You're not going to wiggle out of that, okay? That document is going to be there forever. It's going to be Exhibit 1 when that employee gets the right to sue letter and they hire that lawyer. They're going to get a complete copy of that Civil Rights Commission file. They're going to see all that documentation, and they're going to see what you said about the reason you did what you did. And you later, if you go, well, we did that before we hired a lawyer. Once we hired the lawyer, we realized there was another reason why we really let him go. Never going to fly. You're going to find yourself in a real pickle for having completed that civil rights questionnaire cavalierly. Is that a word? Cavalier? I'm not sure if that's a word. But don't be cavalier when you complete that. Spend time, make sure you say it the right way. Kind of what I say here. Biggest concern comes from misrepresenting the layoff. I get this. Do you offer the opportunity to resign? Always. I mean, I never see a downside to that. I mean, some employers will say, no, we want to send a message to our workforce that you do what that employee did, they're going to get discharged. Okay, that's fine. I get it. I always prefer if you can, the offer of an opportunity to resign. It's more palatable for everybody. An employee that elects to resign is probably never going to sue you for anything. They're not going to make a complaint. They appreciate the opportunity to resign. So if you're wondering, is that something we should do? Yes, you should. To the extent you can stomach allowing them to resign, I think it's a good play. Just a couple of reminders when you're in a discharge scenario. Look at all your personnel file. Do we have evaluations that are sometimes objective? I preach every time about employee evaluations. If you're not going to do them objectively, I would prefer that you not do them at all, because if your only purpose of doing an evaluation is you just check satisfactory in every box, it doesn't serve much of a purpose. That evaluation is supposed to be an objective measurement, and it really doesn't benefit the employer. It benefits the employee. It's a communication piece to the employee. And I know it's hard because these are people we work with every day, and that evaluation tool is something that we then have to explain to the employee. But it's a good reminder that do those objectively, because when I look at a claim and I have to look at evaluations and you're telling me this employee was the worst employee ever, and every one of their evaluations says they were doing a great job, that's tough for me to reconcile when I'm talking to the jury or the judge or the other lawyer. Okay, so just be mindful of that. Is the discipline fair? Why is fairness important? These are employees at will. What do we care? We have the right to let them go for cause or for not cause, any reason or no reason. Fairness is important to juries. We're always amazed when we try cases. Sometimes juries will just get past the law in a heartbeat. They hear the law that the judge instructs and they work their way right through that. And their conversation focuses on, I don't think that was fair. I don't think it was fair that this employee worked for 25 years and they strolled in and they said, hey, box up your stuff and hit the bricks, buddy. You're not cutting anymore. I don't like the way that was. I think they did it in a mean way. I think they could have handled that better. It's amazing how juries will become super HR people when they're in the jury room. They think they got all the answers and they've always got a better way to do something. So just ask yourself, if I was a third person evaluating this scenario, would I feel like the reason we did this was fair? and try to work through your scenario that way. Sometimes you can't, but sometimes I think it's a good practice to follow. Consistent with past practice, it's always a killer when you're letting one person go for attendance. You're not letting somebody else go with the same type of attendance problem. That's what gives rise to forms of discrimination. If the 30-year-old white male has the same attendance problem as the 70-year-old African-American female, and you're letting her go and not him, it doesn't look very good. And that's generally what gives rise to forms of discrimination. So consistency in your practices is always a good practice. Never retroactively paper a file. I've seen too many employers try that. They don't do what they think is a good job of documenting the reasons for separation at the time. So when I go and get involved in a civil rights complaint or something, well, then they'll prepare something after the fact. I mean, then they'll put something in the personnel file outlining all the reasons they let them go. Well, the problem is it's dated 2 months later, and it's clear they did it in preparation for litigation. That's not a good sell. That's all things you want to think about before you get into that scenario. So here is my dilemma, Kelly. I've got slides to go with a number of topics. I know I've probably bored the bejesus out of just about everybody that's still hanging on, but is there certain topics? I mean, I always get to this point. I don't know if I should cover wage and hour, independent contractor issues, any other topics that might be of interest, because I know I'm right up against the time that you told me to shut up.
Yeah, we've only lost 2 people from the very beginning, or maybe a couple more than 2. So if, somebody has something that is, a burning question, you'd want to throw that in the chat, that would be great.
Okay. Well, how about we do this then? I'm gonna try to rip through these slides and just so they'll be up, people can read them, and then if I see something worth highlighting, I will highlight that and move on to the next slide unless someone stops me. Okay.
That sounds great. And of course, this is being recorded and will be available after the webinar, as well as the slides, of course.
Okay. Wage and hour issues. The only thing, last January, we now had a change in the salary threshold. The exemption is now $684 per week or $35,500 per year. So if you're paying people on a salary, remember that's the new salary they have to be paid. And remember also, that's not the only issue. To meet the exemption, to be exempt from the overtime requirements, they have to meet that salary number, and they have to meet one of the duties requirements. That duty requirement is they have to meet the exemption for executive, administrative, or professional. Also, it can be computer employees, outside sales. I bring this up all the time because I think there's still misunderstanding out there. Just because you pay somebody that $35,000 a year doesn't mean they're exempt from overtime. They're not exempt unless they fall into one of these categories: executive, administrative, professional, or computer or outside sales. Okay? Unless they meet one of those, they're still eligible to be paid, and you still must pay them overtime. Okay? I think a lot of organizations still fudge on that, and I get it. There's reasons why you want to, but if you do fudge on that, just be careful. Department of Labor investigation may determine that exempt employee, salaried employee that you weren't paying overtime to is eligible for all kinds of back overtime. They can go back to as long as 3 years and ding you for back overtime if you don't pay them. An employee is not exempt just because you choose to pay them a salary if they don't meet the duties. No rules on break time. Just remember, yes, most employers provide breaks to their employees, but you don't have to. It's not required. There's no law that says you do. Travel time, obligation to pay employee for travel time generally related to the employee's typical work location. You don't have to pay travel time. If they show up at their work location and go somewhere else, then you are paying for travel time. If I show up in Fort Dodge and you send me to Des Moines for the day, you're going to pay my time sitting in that car, okay? If my workplace changes to Des Moines, even if I work in Fort Dodge, if my new workplace becomes Des Moines, you don't have to pay me to commute to Des Moines every day. Then it becomes on me. Unemployment claims, just a couple things. Remember, you can legally discharge someone and still lose the unemployment claim. You can't always be disappointed in losing unemployment claims because the standard is so high to deny benefits. You have to prove misconduct, okay? If you're gonna, when you contest these unemployment claims and you show up for the administrative hearing, don't have your HR person do the whole thing. Have the HR person testify solely to the administrative law judge. Have the people that were really involved in the decision and the people that really have firsthand information about the type of misconduct. They should be there as witnesses. So often the HR person is the only person that handles that. And when the question comes in from the administrative law judge, well, what was the reason for letting him go? And the HR person says, well, according to the plant manager, they did this wrong and did that wrong. And the plant manager's not there to testify. You're almost always going to lose those. Independent contractor. I get a lot of these questions, folks. I think, again, there's a lot of fudging that goes on by employers, and there's a lot of reasons why they want to. There's a real incentive to declare your workers to be independent contractors rather than employees. You can avoid a lot of costs. They're not covered by work comp. They're not covered by unemployment. Those things are out there, but be mindful that there's a test. For it really to be an independent contractor, the IRS, the Department of Labor, Workforce, they follow a test. And the test is really to determine whether or not that individual was more closely aligned with a contractor or an employee. Even if you and your worker decide they're a contractor, that's not the end all be all, okay? You may all agree that I'm a contractor, Stu, you're a but the work I'm doing may be more closely aligned with that of an employee, and that's going to be the end result. I'm going to be determined to be an employee regardless of what the party's intent. The party's intent is just one of those factors that I just threw up on the screen that they look at to make that determination. Drug testing, again, this comes up every year. If you have a drug test, if you drug test, you must have a drug testing policy that meets Iowa law. Iowa law has the most restrictive drug testing statute in the country, #1. So what happens is so many people want to do drug testing, so they jump online and they get a drug testing statute online that is prepared by a publishing company somewhere to address drug testing. They almost never meet Iowa law because Iowa law is really unique. It's by itself. If you're going to do any drug testing in Iowa, you must have a policy that complies solely with Iowa law, okay? Then, if you have that drug testing policy in place, only when you have it in place, you can do drug testing. You can do pre-employment, you can do post-accident, but you can only do post-accident if there's damage to property or personal injury that exceeds $1,000, okay? You can do random, but random is not what we think of as random. Random drug testing means you're using corporate health over at Unity Point, and they're putting it on a software program. And every week or month or year, however often you want to do it, it kicks out the names randomly of 10 people to drug test. That's what random drug testing is. Or you can do reasonable suspicion drug testing. That means something happens that gives you a reason to believe that someone might be under the influence. Those are the only types of tests you can do. But you can't do any of them unless you have a drug test policy that complies with Iowa law. Okay, that's what those last 2 slides are talking about.
Sorry, Stu. I was a little behind and my internet kind of cut out, so I got kicked out. So I do have another question, and forgive me if it got answered while I was offline. If you have an exempt employee that you do pay overtime, must you recalculate their hourly wage if you pay them a monthly bonus?
Great question. The answer is yes. The answer is yes, because it depends on if it's a discretionary or a non-discretionary bonus. Here's the type of bonus that you do not have to include in their wage calculation. A Christmas bonus. Every year a company decides, well, have we been profitable? If we've been profitable, we will decide at the end of the year to pay out a discretionary bonus, okay? Maybe we give every employee $200 or $300 just because we feel like doing it at the end of the year and we're not obligated to do it. You do not have to include that discretionary bonus in their calculation. But if it is a bonus that they can earn, they know what they have to do to get it. If they work every day, they don't have a day of absence for 30 days, they automatically get $500. That's a non-discretionary bonus because the employee knows what they have to do to earn that bonus. If it's something that they can take action to earn and there's a pre-established way or goal that if they accomplish that goal, they get the bonus, then it becomes a non-discretionary bonus. And yes, you have to factor that bonus into their regular compensation to determine their overtime rate. Did you get that, Kelly?
I think you did. Thank you.
Okay. Just a couple more. I got non-competes. Everybody wants to do non-competes these days, and I get it. And I do a lot of them. I review them for employees. I draft them for employers. Non-competes are weird under the law. I don't mind drafting them, but I tell every employer, I can draft this as narrowly as you want. I can make it as restrictive as you want. Understand that at the time it's challenged, these will all be evaluated on a case-by-case basis to determine whether or not they're enforceable. A judge in Iowa has the complete discretion to decide whether to enforce the non-compete or not, depending on fairness and the circumstances at the time of the separation by the employee. If you're a teacher subject to a non-compete, never going to fly because the marketplace needs teachers. If you're a healthcare provider and you want to leave your employer, but you've got a non-compete and you want to go somewhere else, and what you do is so underserved, you're so needed, you're valuable, the service you can provide is so necessary in the community, a judge is never going to enforce the non-compete. So the question always becomes, I'm happy to provide these, and I evaluate them all the time. And sometimes they really do have merit, but just understand they have to be narrowly drafted. The devil is in the detail. If you draft them carefully, you can get them enforced. If you don't draft them carefully, the chances of having them enforced are really iffy. You see very few of these actually go to court anymore. Most people negotiate them out after they arrive at, what's a fair arrangement? Maybe we can reach a compromise. We had a 3-year non-compete. Maybe we'll reduce it to 6 months or a year if you can live with that. If you don't take our customers from us, we'll agree that you can go work somewhere else. Just leave our customers alone. Those are the sorts of things that generally resolve non-compete issues that arise after the employee leaves. So I just wanted to address that with non-competes. I do them a lot, and I do. I enjoy drafting them, and I draft them just the way people want them. But I'm always careful to let them know I can only put it on paper. I can't make the judge enforce it. Wage claims. Before you ever deduct from wages, make sure it's authorized by the employee. There's only certain things in Iowa under Chapter 91A where an employer has the right to deduct from someone's wages. Unless they've given you written authorization, you can't do it. And then there's new case law out there that says not only must they provide written authorization, but it must be for the benefit of the employee that you're doing the wage deduction. So I really struggle with that. I go, well, why would we deduct for the benefit of the employee? And I think here's the rub. A lot of employers make an arrangement like this. The employee signs a form that says, I understand if I don't give 14 days notice before I leave work, if I don't give you 14 days notice, you can deduct 14 days pay from my wages. I hereby authorize you to do that. I will tell you, I think that even though you've got authorization, I think it's illegal. It's illegal because the employee got no benefit out of that. okay? All it did was benefit the employer by getting the 14 days notice, okay? So before you just have any type of deduction from an employee's wage, make sure it's permitted under Iowa law. Otherwise, the consequences are really serious. Liquidated damages, you pay all the attorney's fees to the employee. I don't like defending wage claims when I represent an employer if I don't have to, because the exposure is so great for the employer. So just really be mindful of those types of claims. Work comp, I don't even know why. You guys know work comp as well as I do. I just threw that in there. One question I have been getting asked relates to COVID. And the question is, if my employee gets COVID, am I looking at work comp claims? So far, the answer to that is no. Okay, right now, none of us know how we contract COVID. I don't know how I got it. I mean, I got it in August, and I don't know, did I get it at work? Did I get it somewhere else? Did I get it at Hy-Vee? Did I get it at Walmart? None of us really know how we contract COVID, and that is a requirement to bring a work comp claim. You have to prove that the injury or illness arose out of in the scope of employment. If I can't prove that I got COVID while I'm at working, I can't make a work comp claim for my COVID illness. So some creative lawyer may find a way to get around that. We have not seen any of that yet, and we actually think that there are not going to be valid work comp claims regarding to COVID. Same thing with general liability. Employers ask, are we going to be liable? What if a bunch of our workers get sick? Are we going to get sued over COVID? The answer again is no. First off, work comp is an exclusive remedy for your workers. Secondly, there's no evidence out there where we can pinpoint how we contract COVID, okay? Until we know more, I don't think we've got any risk. And I just threw that in there regarding migrant and seasonal workers. I don't think there's anything new or exciting about that. So that's the end of my slideshow. Sorry I took so long.
No problem. I don't see any additional questions. Yeah, I think I don't see anybody jumping up, and raising their hand. So, Stu, I want to thank you so much for all the knowledge, and I think everybody would obviously give you a round of applause. If you see Stu out, maybe buy him a cup of coffee or a glass of wine, depending on what time of day it is. But what a great information, and a lot of free advice from Stu. It's invaluable. So thank you, and thank you, Sharon, for participating as well.
Thank you for having us, and thank you, Stu. It was great.
Good, thank you.